final Paper-7 direct tax laws. I am Priya Subramanian.
Good morning, students. I am Aparna, Chauhan.
And together we'll guide you through the session. Basically, we'll be covering the amendments made by the Finance Act 2015, which is all these amendments are applicable for May 16 and November 16 examination. So basically, we'll be concentrating on the latest amendments.
Before moving to our session, the students please note the disclaimer statement. ICDS has a student learning management system wherein the students are advised to refer to e-lectures available on the student elements for this and other topics. They are freely accessible and they have to just register with their student registration number. Other than this, students are also advised to refer to the study material, including supplementary study material, if any, and other relevant legislation for latest provisions, amendments required for the forthcoming examination.
So what is the, I'm sure you'll all be knowing by now, but anyway, for a recap, what is the assessment year applicable for May 16 examination? It is assessment year 1670. The Income Tax Act 1961 as amended by the Finance Act 2015 is applicable. And as far as notifications and circulars are concerned, the cutoff date is 6 months prior to the examination. Therefore, circulars and notifications issued up to 31st October 2014 are relevant. So what are the BOS publications relevant for May 16 and November 16 examinations? There are 5 publications which we have mentioned here. The first 4 publications are relevant for both May 16 and November 16 examination. That is the study material, the November 2015 edition of the study material. This edition is based on the provisions of direct tax laws as amended by the Finance Act 2015. In case you have the earlier edition, that is the November 2014 edition, then you should read the same along with the supplementary study paper 2015, which explains the amendments made by the Finance Act 2015 and notifications and circulars issued up to 30th April 2015. So November 2015 edition is relevant for May 2016 examination. Practice manual. Practice manual contains the questions from past examinations which have been adapted and answered on the basis of provisions of direct tax laws as amended by the Finance Act 2015. Practical questions have been adapted and answered on the basis of the provisions of tax laws applicable for assessment year 1670. So, these two other study material and practice manual, editions of study material and practice manual which are relevant for May 16 examination as well as November 16 examination. Now, in case you have the earlier edition of the study material, in case you have the November 2014 edition, you can read the same along with supplementary study paper 2015, which discusses the amendments made by the Finance Act 2015 and circulars notifications issued during the period from 1/5/2014 to 30th April 2015. So, in case you have the earlier edition, you have to read it along with the supplementary study paper. Even if you have the latest edition, even if you have the November 2015 edition of the study material, I would still advise you to go through the supplementary study paper since the illustration exam amendments are explained with the help of illustrations and tabular presentations, and weightage is being given to latest amendments in the examination. So definitely go through the supplementary study paper. So all these publications are in fact hosted at the BOS Knowledge Board. As far as select cases contains the judicial update, and the August 2015 edition of the select cases are relevant for May 16 examination. And RTP for May examination, apart from containing the questions, it will also contain the statutory and judicial update for the last 6 months, which are relevant last 6 months, that is up to 31st October 2015. From 1/5/2015 to 30th October 2015, this is a statutory update as well as the judicial update will be given in the RTP. Apart from that, RTP also has the questions for self-examinations. Now, as I told you, the latest amendments and case laws relevant are given in the supplementary study paper, which covers the amendments by the Finance Act 2015 and significant circulars notifications issued between 1/5/2014 and 30th April 2015. And RTP for May examination will cover between 1/5/2015, after this date, 1/5/2015 to 31st October 2015. Judicial update, you have to read the select cases August 2015 edition and the annexure to the RTP for May 2016 examination. In addition, 2 cases have been posted as an on the website as an appendix to the RTP. 2 additional cases, Supreme Court cases, which are very much important. So kindly go through that also. It's given as an addendum to the RTP and it's hosted at the BOS Knowledge Board. Now, how to prepare for the examination? All of you, it must have been it is just a few days before the examination, so I'm sure you must be in advance, and this is more relevant for students appearing for November 16 examination. So you should know as a first step, before you start any subject, you should know the syllabus as well as the expected level of knowledge. At the final level, an advanced level of knowledge is required. And as far as applicability of Finance Act and assessment here, this you must be very clear. The amendments made by the Finance Act 2015 are applicable for May 16 and November 16 examination. The relevant assessment here is assessment year 16-17. So firstly, you must draw up a detailed study plan. This is more relevant for November 16 students, because I'm sure as far as May 16 students are concerned, they will be in the advanced stages of their study. So you draw up a detailed study plan and allocate time for each topic of the subject. The content of the practice manual and the study material both together will help you to decide how much time to allocate for each topic. So initially you start on the basis of study material and practice manual, and you allocate time for each topic. Later on, you can always revise your timetable if you feel some topic needs more time than what you initially estimated. Read each chapter of the study material thoroughly for conceptual clarity. You should be clear with the concept. Mere rote learning will not help. And at the final level, everything is application oriented. You should know to interpret the sections. You should know to apply the provisions of law in solving any computational problems or any other type of practical questions. So you should understand the concept thoroughly, and for that, read each chapter of the study material. Once you complete reading a topic thoroughly, work out the questions from the corresponding chapter of the practice manual. You have to work it out. Here you should not read it, because practice manual tests your application skills. This is for a study material, will help you to acquire knowledge. Practice manual will teach you how to apply the knowledge which you have gained by reading the study material in problem solving. So you work out the questions on your own. Thereafter, compare your answers with the answers given in the practice manual. This will help you to identify your gray areas where you actually have to you're not clear with any particular concept, you end up making a mistake in that particular adjustment. So you go back and understand what is actually the correct provision. In this manner, you proceed with each topic. First, do the study material. Thereafter, work out the questions in the practice manual, and then compare your answers with the answers given in the practice manual. And when you're comparing the answers, see the manner in which the answers are presented in the practice manual. Of course, practice manual is much more in detail than what you would be able to write in the examination circumstances. But broadly, it gives an idea. It tells you about the importance of reasoning when you write any answer. So after you've repeated the process, do the study material and then the practice manual. For each topic wise, you first repeat it. Then once you complete all topics, do the questions in the practice manual, work it out once again, so that you tie up all the loose ends, whatever areas, problems where you were going wrong at the first instance. And the second time when you work out, you must be very clear about the application of your concepts, right, in problem solving. Then, when you finish this entire exercise, you've finished solving the practice manual once again, then you can also solve past year question papers with the help of suggested answers, as well as mock test papers hosted on the Institute's website. Here, you should do it within the time span of 3 hours. You're going to self-assess your preparedness for examination. So keep the time frame of 3 hours in mind and accordingly try to answer the question. Also, you can solve the questions in the RTP to self-assess your preparation for the examination. Now, this is most important for those who are attempting May 16 examinations, how to manage time in the examination. You just have a limited period of 3 hours. You have to answer the 6 questions there. How do you go about answering so that you can fetch maximum marks? For that, you have to first make use of the 15 minutes reading time given for each paper effectively. So in that 15 minutes, read all the questions. Then identify which question you know best, which would you would like to take up first, and answer that question. Always answer the question which you're very confident first, because the first impression, it will help build an impression. So answer the question which you know first, but once you've chosen a particular question, whether it's question number 4 you've chosen, then answer all the subparts one after the other in the same place. Don't answer one part of a particular question, then go to another question, then come back to the second part of the question. That does not convey a good impression. So, and decide the manner. Suppose you know question 4 first. So answer question 4. After that, you know question 5. You answer question 5. Then you come to question 1. All the subparts of question 4 you'll answer along with question 4. All the subparts of question 5 along with question 5. Then you come to question 1. Like that, you have to totally answer 6 questions within the time span of 3 hours. So accordingly, you plan your time schedule, how you will go about answering. Don't spend too much of time answering in one question that it eats away the time available for other questions. Because ultimately, if you're going to give your best for 4 questions or 5 questions and leave the 6th question, you will be losing a lot of marks. So time management is very much important when you answer. Don't make your answers too sketchy. That is not required. Bring out the provision of law clearly. Keep 10 minutes at the end for checking your answers. In case there is some problem, like something you have left out, something, keep 10 minutes in the end. 10 minutes cushion in the end for checking your answers. So this is the way you go, and important points you can underline. Underline with your pen itself. Don't waste time taking a scale and a pencil to underline it, because your time management is very important, because in direct access paper, you would hardly get any straightforward knowledge-based questions. All the questions are application-oriented, and it involves interpretation of provisions of law. So for all that, it is very important that you manage your schedule your time effectively. And even those questions which involve interpretation of provision of law, you decide the manner in which you'll be answering such questions during the 15 minutes time itself. So this 15 minutes time you have to utilize very effectively. Would like to add something, Aparna?
Yeah, here I just want to add thing that in case you have to solve all the parts of one question at one place. So हो सकता है कि कुछ पार्ट आपको नहीं आते हो, तो आप यू आर इन ट्रबल की आप ये क्या करिए, हम नेक्स्ट क्वेश्चन सॉल्व करना चाहते हैं, तो ट्राई टू solve all the parts at one place. So what you can do, you can leave the space for that part and start with the other question in which you are comfortable and you can attempt it very well. So after finishing all the other questions, then you can come to that part and then try to solve that question, try to make the solution of that question. This thing. There's one thing here that everybody plans very well, I think. आप प्लान कर लेते हैं, बट द प्रॉब्लम कहाँ अराइज होती है, वो इम्प्लीमेंट नहीं होता. सपोज आपके पास 1 month है, अब आपके पास 28 चैप्टर्स है. नाउ यू मेक कि अब मैं 2 days फॉर दिस चैप्टर, 3 days फॉर दिस चैप्टर, फिर पता चलता है 10 days बचे. 10 days में अब ना हो, आपको पता चले कि आपके पास अभी भी 25 चैप्टर्स फिनिश करने हैं. तो अब आप वहां पे जाके फंस जाते हैं, वहां पे फिर आप कॉन्फिडेंस लूज करते हैं. इससे बेटर कि जैसे इन द मैनर यू प्लान योर स्टडीज, implement your plan in that manner only. Don't postpone for the next day or the other day. Try to do that chapter on that same day. And since the direct tax laws is a very or in case of that you are appearing for the exam, don't waste the time on the question in which you are not very much confident, you have some doubts there. So try to solve the first question in which you are very much comfortable. You know that it will definitely fetch a marks, good marks, but don't spend so much of time on that question, and try to solve all the 6 questions which you have to attempt in the question paper.
What we are trying to tell you basically, suppose you choose a particular question 4, you're very confident, you know the chapter very well, and you spend 1 hour time in answering that question, you'll be left with just 2 hours for answering the remaining 5 questions. There, again, you'll be struggling. So even if you know the question very well, you try to keep it within the schedule for half an hour for each question. You will be able to cover 6 questions. It might be, instead of half an hour, one question might take 35 minutes, another question might take 25 minutes. But don't stretch it off to 1 hour, one question for 1 hour, because you'll struggle with the other questions. How to score good marks in this paper? DT is perceived to be a very tough paper in the sense that it involves application. Mere rote learning of any provisions of law will not help to score good marks. So it is necessary that you understand the provisions clearly so that you are able to apply those provisions in problem solving. So answer the questions with undue emphasis on the provisions of law. Your answers will always be with reference to the provisions of law or with reference to a case law, or both. You don't make your answers on the basis of surmises or guesswork. In case of computational problems, supplement your computation with working notes, explanatory notes. Support the treatment with provisions of law and/or case laws. For example, the second question is generally a question on total income, and it gives various adjustments. Majority relate to general tendencies to relate to profits and gains of business or profession. So you have to add certain disallowances, reduce certain items which have been credited to the profit and loss account but which are not actually forming part of business income. So when you do that, now you have to give a brief reasoning for your answer. Suppose I'm making some addition on account of non-deduction of tax, so 30% is disallowed. So you, after you make put 30% of 1,30,000 is disallowed. You in that note you write, as per section 40A1A, since tax has not been deducted at source at the time of making payment, 30% of the said payment has been disallowed. This note has to come for each and every disallowance. In case of suppose some expenditure on scientific research, contribution for scientific research has been debited to P&L account and it qualifies for 200% deduction. Then once more 100% has been debited, another 100% will be debited. So you say that is because you get weighted deduction of 200% under 35(2)AA or for in-house scientific research under 35(2)AB. So this point should be clearly brought out. So the treatment, guys, your answer might be fully correct. You might have solved the correct problem correctly. Your total income will be correct, but still, unless you've given a proper reasoning for each and every disallowance or deduction, your answer will not fetch marks. I'm just trying to emphasize the importance of working notes as well as notes for reasoning. Then relate and apply the ratio of court rulings and case law based questions. In fact, this will be taking up separately now, how to answer a case law based question. They will cover it in detail. Mentioning section numbers and case laws will add value to your answer. Definitely, if an examiner is evaluating the papers, he finds that you've written the correct section. If you've been able to quote a case law, it helps to build a good impression. Case law, matlab, not the full citation, at least the name of the party. If you're able to bring out, it conveys a good impression. But if you're not sure about the section number, please don't quote a wrong section. You might end up losing marks for quoting wrong sections. So only if you're sure about the section number, you're sure about the name of the case, then you write it. State your assumptions and views clearly. Tax laws are prone to many assumptions. There are different assumptions. If the question is silent relating to a particular thing, relating to say most commonly payment of gratuity, whether the employee is covered under the Payment of Gratuity Act or he is not covered, it's a two different set of computations in such a case. And the question is silent as to whether the employee is covered or not, then you make an assumption and proceed to answer the question. Avoid using, as regards views, it may be based on High Court rulings. There might be contradictory High Court rulings. Then which High Court to choose? So according, if you're going pursuing on the basis of course, if there's a Supreme Court ruling overruling one particular High Court, then you have to go as per the Supreme Court ruling. But in case of High Court rulings which are contradictory to other, you can follow either of the views, but state your views clearly. Avoid using short forms in your answers. Unless absolutely you're running short of time, you have to use it, then it's a different matter. But otherwise, for presentation of your answers, avoid using short forms. And this we've already discussed the last one. Write all parts of the same question, one after the other in continuation. If you choose a particular question, question number 5, answer A, B, C of that question continuously one after the other. These are a few tips to score good marks in this paper. And of course, have proper rest before the examination. See that you sleep well. See that you maintain a good diet so that you are very fresh and you have the stamina to sit for the examination and do the paper properly. Do you have anything to add, Aparna?
One thing I can say that highlight your important terms or the important provisions of the law. So that in the examiner, if you check your copy, so the highlighted portion will directly he can view it clearly, and in that way your important portion of the answer will be highlighted. By how you can highlight, you can underline it, underline the important words, important terms in your solution, or you can write the that terms or the solution that part in a capital letter also. You can do that in that manner. Or first you don't write your solutions in a long or very lengthy paragraphs. Try to divide your solution in the parts, in the short sentences, in the short paragraphs, right? These are the few tips I think you can follow them for answering.
Ideal manner of answering a case law based question. Here again, there is a particular, generally there's at least one question in the direct taxes paper which has subparts containing based on recent case laws or landmark case laws. How do you answer? Students generally don't score well in that, because although they've read all the cases in the select cases, they know which case law actually on the basis of which they should answer in the examination, but still they don't score marks because they don't know the proper manner of the answering a case law based question. Merely knowing which case to apply will not fetch you good marks. You have to follow the following steps for a better presentation of a case law based question. First of all, it's important to identify the issue raised in the question. What is exactly the issue raised in the question? The issue raised in the question is whether when a commercial property, say, is let out, whether the income therefrom is taxable under income from house property or business income. That might be the issue you're addressing in the question. Bring out that issue at the beginning of your answer. Then you may basically discuss the related provision of law. In this case, what is the related provision of law? Related provision of law is Section 22. Section 22 states that income from all property except the property which the owner occupies for the purposes of his own business or profession, it will be chargeable to tax under the head income from house property. So bring out that Section 22. Thereafter, if you remember the name of the case, mention that the issue has been dealt with. This issue has been dealt with in so and so case, wherein the High Court observed as follows. So that you can mention. If you know the name of the case, do mention the case. It will add value to the answer. Then discuss the rationale of the court ruling. Highlight the decision. What decision was finally arrived at in the case. Then you apply the rationale of the court ruling to the case on hand, to the question which has been raised, and give a conclusion to your answer. It's very much important that you give a conclusion. The question may ask whether is the assessing contention or assessing officer has taxed the income from letting out of commercial properties under the business income. Is the contention of the assessing officer correct? That is the question. Now, you discuss the provision of Section 22, you discuss the relevant case law. Thereafter, you have to give a conclusion that based on the rationale of this court ruling, the contention of the assessing officer is incorrect. That conclusion also fetches marks. So, identify the issue, identify the provision of law, and then if you remember the name of the case, mention that the issue has been dealt with in that case, then highlight the decision of the case by bringing out the rationale of the court decision, and then give a proper conclusion as to whether the contention of the assessee or assessing officer, as the case may be, is correct or not. Remember, don't repeat the facts of the case as given in the question paper. You will end up wasting time. Of course, no marks will be awarded for that because those are already there in the question paper. Everybody knows, the examiner also knows that you've taken it from the question paper. So unnecessarily you will end up wasting time. The facts of the case are not required for answering a case law based question. So generally these questions tend to be for 4 marks. So bring out these points: the issue, the provision of law, the rationale of the court ruling, and then your conclusion. Now let me explain this with an example. This is a famous, this is based on a recent Supreme Court case law. Airline company Comair Limited paid 12 lakhs during the year ended 31/3/2016 to Airports Authority of India towards landing and parking charges. Company deducted tax at source at 2% under 194C on the said payment, remitted the tax deducted within the prescribed time. Assessing officer contended that the landing and parking charges were levied for use of land of airport, and hence payment was in the nature of rent, attracting TDS at 10% under 194I. Discuss the correctness or otherwise of the contention of the assessing officer. So what is actually happened? The assessee has deducted tax at 2% on these charges. Assessing officer says no, these charges are in the nature of rent, so you have to deduct tax at 10%. Now, is the contention of the assessing officer correct or not? That is what you will have to discuss. In this regard, there were earlier 2 contradictory views of Madras High Court. Madras High Court said that these landing and parking charges will be subject to TDS at 2% under 194C, whereas the Delhi High Court said no, it is in the nature of rent under 194I. Now this issue has been settled since the Supreme Court has now decided. What is it? Supreme Court has said that these charges are in the nature, the charges which are fixed by the AII, Airports Authority of India, for landing and takeoff services as well as for parking are not for the use of land. These charges are for the services and facilities offered in connection with the aircraft operation at the airport, which include providing of air traffic services, ground safety services, aeronautical and communication facilities, etc. Of course, you need not write each and everything. You can write it's not only use of land, it's for a variety of other services also. Therefore, they cannot be considered as payment for use of the land. So, Supreme Court concurred with the view taken by the Madras High Court, and it overruled the view taken by the Delhi High Court. Delhi High Court, it said that it was rent within the meaning of 194I. So the Supreme Court overruled it because those charges were not only for use of land, it was for several other charges as well. Therefore, applying the rationale of the Supreme Court ruling to the facts of this case, the contention of the assessing officer that landing and parking charges are for use of land at the airport and hence are in the nature of rent to attract the provisions of TDS under 194I is not correct. Here you can bring out the definition of rent briefly as under section 194I. That also you can bring it in one line. Because why is the Delhi High Court argued? Because rent includes payment for use of land. But this payment is not only for use of land, but it's for other services as well. So TDS under 194I is not attracted. So the contention of the assessing officer is not correct in this case. Now let us take up the significant amendments made by the Finance Act 2015.
In the rates of taxes, Finance Act 2015 does not make so many of the changes in rates of taxes. Like in case of basic exemption limit, the basic exemption limit remains the same. That is in case of an individual, HUF, AOP, BOI, artificial juridical persons remain unchanged. That is rupees 2,50,000. In case of a senior citizen, the person who is a resident of India or a person who is of the age of 60 or more, the basic exemption limit also remains same, that is of rupees 3 lakh. Up to 3 lakh, no tax liability arises. In case of various senior citizen, means being a person who is a resident of India and who is of the age of 80 years or more, the basic exemption limit is same, that is 5 lakh. In case of surcharge, however, there are changes. In case of surcharge, the surcharge rate will increase from 10% to 12%. In case of individuals, HUF, BOI, artificial juridical person, cooperative society, local authorities, firms and LLP, where the total income exceeds rupee 1 crore. Here, see the words that when the total income is of 1 crore, then no surcharge will be payable. However, when it exceeds even for by a 1 rupee or 1 crore, then surcharge is payable at the rate of 12%. In case of a domestic company, the surcharge rate for in case of domestic company is in 7% or 12%, depends on their total income. If the total income is 1 crore, is more than 1 crore, then less than 10 crore or equal to 10 crore, then surcharge is payable at the rate of 7% of income tax. The surcharge is always payable of the income tax. In case of domestic company whose total income is more than, it exceeds 10 crore. If it is up to 10 crore or 10 crore, it is 7%. When it exceeds to 10 crore, the surcharge rate is 12%. Earlier it was 10%. There is an amendment in residential estate. In residential scope of total income. What is this amendment? Section 6(1) deals with the determination, a manner in which the residential status of a person is determined. As per section 6(1), there are conditions laid down. Then, in what case the person is individual will be treated as a resident in India. In there, two conditions. One, that if it depends on the period of stay of that individual during the previous year. In first question, it should be 182 days or more during the previous year. Then that individual will be treated as a resident of India. In the second condition is now that if the first condition is not satisfied by that individual, then we will move to the second condition. We have to check whether that individual is satisfying that condition. Then in that case, what is that condition? The person has to be in India for 365 days or more during the 4 preceding previous years, and 60 days during the previous year. 4 years preceding the previous year, 365 days plus 60 days during the previous year. 365 days plus 60 days. 4 previous years preceding the previous year is previous. So in that, these conditions, there are certain exceptions that in what cases this condition will not be applicable. This is provided that where an Indian citizen leaves India as a member of crew of an Indian ship or for the purpose of employment outside India, then in that case, that person, the Indian citizen will be resident of India only if he stayed in India for 182 days. Now, there are certain uncertainties. What in case of foreign bound ships, where the destination of the voyage is outside India, there is uncertainty regarding the manner in which the residential status has to be determined, the basis for determining the period of stay. To remove that uncertainty, this explanation has been inserted to section 6.1, which provides that in case of an individual being a citizen of India and a member of a crew of a foreign bound ship leaving India, the periods of stay in India shall, in respect of such voyage, be determined on the prescribed manner. The manner has to be prescribed. So the CBDT is authorized here to prescribe the manner prescribe the manner and the condition for determining the period of stay of a individual being a citizen of India and a member of crew. So now, what is that manner? The CBDT now comes with a notification, that is notification number 70/2015, dated 17/8, in which it lays down that for the purpose of section 6.1, in case of an individual or member of a crew, the period of stay in respect of eligible voyage shall include the period beginning on the date entered into the continuous discharge certificate in respect of joining the ship, or ending on the date entered into the continuous discharge certificate. So there are certain terms arises. What is this eligible voyage? Here we have to exclude certain period. So we will see what is that period and what is this eligible voyage. The eligible voyage is means a voyage undertaken by a ship engaged in the carriage of a passenger or freight in international traffic where the voyage been having originated from any port in India and destination is outside India, or either way, it's originated from outside India or destination is in India. So that voyage which carries passenger or freight in international traffic is considered as the eligible voyage. If that person is a member of crew or is going to in that eligible voyage, then the period which is beginning on the date entered into the continuous discharge certificate. Continuous discharge is an identity of the identity card type which is given to the member of a crew or the person who are working on that eligible voyage. So they have to enter that date in which they join that ship, or they have to sign off that. So they have to sign the date entered into the ship, entered into the continuous discharge in respect of joining the ship, or the date entered into continuous discharge certificate, signing off by that individual from the ship. So the period inclusive of both the dates, that is the joining date and the signing of that date, has to be excluded while determining the period of stay of that member of a crew of that person. So what are the things you have to exclude this period for computing the period of stay during the previous year, and if you satisfied, if you complete the period of 182 days or more during the previous year, then only he will be considered as a resident of India. Here I have covered. I will explain this with an aid of an example illustration that in case of Mr. Anand is an Indian citizen and a member of crew of a Singapore-bound Indian ship engaged in carriage of passenger in international traffic. So it is an eligible voyage. It is destination departing from Chennai port, arriving to the Singapore. So it is an eligible voyage. From the following details, what you have to do, you have to determine the residential status of Mr. Anand for AY 16-17, assuming that his stay in India in the last 4 previous years, preceding previous year 15-16 is 400 days, and the last 7 previous year preceding 15 is 750 days. So in that case, what we have to check that what is the period has to be excluded while determining the period of stay in India. So the date which is entered into the continuous discharge certificate in respect of the joining of the ship is 6 June 2015, and the date entered in this certificate in respect of signing of the ship by Mr. A is 9 December. So this period inclusive of 6 June and inclusive of 9 December has to be excluded from 366 days in a previous year for determining the residential status. So what that period would be? This period is 187 days. It's 25 days of June month, then July, August, September, October, November, and 9th of December. So this period comes to 187 days. Have to be excluded from the period of his stay in India. So total period, total days in the year is 366 days. We have to exclude this period 187 days. Now it comes to 179 days. So in Mr. Anand, period of stay in India during the previous year 15-16 would be 179 days. it is less than 182 days. So he is a non-resident in India. So the other information that is relating to the previous year's 400 days is irrelevant in that case, because since he is a non-resident, by excluding this period, we are not bothered about these other information given in the question. This is relating to the residential status amendment. Now we move to the profits and gains from business or profession. What are the amendments in this chapter? Additional depreciation. There is an amendment in relation to the additional depreciation. What happened in case of additional depreciation? Additional depreciation is allowable to everybody. No, I think section 32(1)(2)(a) provides for that in case of a manufacturing company who invest in a new plant and machinery or a power sector undertaking would be eligible for 20% of the added cost of the new plant and machinery acquired and installed during the previous year, for 20% of additional depreciation of the cost of that machinery. Now, there is a proviso, second proviso, which restricts that if a plant and machinery which is put to use for less than 180 days, then in that case, the whole only 50% of the normal depreciation as well as the additional depreciation would be allowed. Now, what happened? What happened? The manufacturing sector or the companies which invest would defer their investment to the next year to avail the 100% depreciation. In case of normal depreciation, since it is available on the WDV, you will be allowable the rest of the balance depreciation the next year. But in case of additional depreciation, since it is available for 20% is available on the actual cost of the plant and machinery, they will be lose their that benefit. They will not be avail the 100% benefit, which is allowable. So in that case, to remove this discrimination in the matter of allowing additional depreciation on the plant and machinery used for less than 180 days, vis-a-vis used for 180 days or more, third proviso been inserted. The third proviso been inserted to section 32(1)(2). In that case, kya hoga, the companies which are losing their 100% benefit, that benefit will be available to them. In that case, what happened? That 50% of the additional depreciation they were not able to claim during the previous year, they can carry forward to the next year and claim in the subsequent previous year. So the balance 50% of the additional depreciation on that new plant and machinery acquired and which is used for less than 180 days, which has not been allowed in the year of acquisition installment, shall be allowed in the immediately succeeding previous year. Now take an example to have a better understanding of this provision. Here is an XYZ Limited, a manufacturing concern. It is manufacturing concern, right? So it furnishes the following information. Its opening WDV of the plant and machinery as on this is 30 lakhs. Now this company purchased a new plant and machinery and put to use on 8/6/2015. It seems that it's used for more than 180 days, right? It's used for more than 180 days. So it will be eligible for 100% depreciation for normal depreciation as well for additional depreciation. This is since this is a new plant and machine, it would be eligible for additional depreciation also. And then another machinery also he acquired, that company acquired and put to use on 15/12. This is used for put to use for less than 180 days. So this machinery would be eligible for 50% of the normal depreciation as well as the 50%. Now the other information is that it purchased installed in office premises on 2/1/2006 put to use for less than 180 days. It around 3 lakh. So this is installed in office premises. The plant and machinery excludes the from its purview. So this is not this for additional depreciation, right? Here, this opening normal depreciation 15% would be eligible. In case of this machinery, 20 lakhs, it is also eligible for 15% plus 20% additional depreciation. This machinery is eligible for 7.5% normal depreciation plus 10% additional depreciation. Computers, it is eligible for at the rate of 60%, only 50% is eligible, normal depreciation 30%. Now you will see how you compare how you proceed with this solution. So same 50 lakh, it's total of 30 lakhs. This is the total of 30 lakh opening WDV plus the plant purchase on 8/6 and the plant and machinery acquired on this day. 50 lakhs. It's earlier 15%. So it comes to 7.5%. The plant and machinery which is put to use for less than 180 days, it comes to 60,000. Machinery, normal depreciation here. This is normal depreciation working. 30% in case of computers, it comes to 90,000. In case of additional depreciation, this comes to 20%, eligible for 100% since it is put to use for more than 180 days, 4 lakhs. And the plant and machinery which is put to use for less than 180 days on 8 lakh, it comes to 80,000. So here the 50% of this amount is this company is eligible to carry forward to the next year, and they can claim this benefit, the rest of the 80,000 depreciation in the next succeeding previous year, that is the previous year 16-17 depreciation. In this manner you proceed to solve this illustration. Now there is another amendment. They bought with a new section 32AD. This is a kind of incentive given to the persons who sets up the manufacturing industries in a notified backward areas of specified states, and they would be eligible for a deduction at the rate 15% of the actual cost of new plant and machinery acquired and installed during the previous year. आपको पता होगा that section 32AC is also kind of similar kind of benefit which is given to the company manufacturing sector. So they have to, what they have to do, they have to acquire and install a new plant and machinery, and they will be eligible for a reduction of 15%, provided the actual cost of that plant and machinery should exceed 25 crores. Here there is no such condition that the cost of the plant and machinery, what would the cost of plant and machinery would be eligible for this deduction. Here the condition is that they have to set up the industry in the notified backward area of the specified state. What are these specified states? It's with Andhra Pradesh, Bihar, Telangana, and West Bengal. So these states, the notified backward areas of these states would be eligible for this deduction. If any person who sets up an industry, manufacturing industry in the notified backward areas of these states would be eligible for this deduction, right? And then what is that deduction? It is 15% of the actual cost of new plant and machinery. Everybody, every assessee, every person would be eligible here. While in case of 32AC, only corporate assessees are eligible. Here, whatever kind of assessee, if they set up the industry on or after 1st April 2015. ऐसा नहीं है कि अगर आपने इंडस्ट्री पहले सेटअप की है 2015 से, and if you acquired in those areas and you acquired a new plant and machine this year or up to this, you would not be eligible for this deduction. These are the both cumulative conditions. They have to satisfy both these conditions, that they have to set up the undertaking or the enterprises on or after 1st April 2015, and you have to acquire and install the new plant and machinery between the period 1st April 2015 and 31st March 2020 in the said backward areas. At presently, CBDT comes with a notification that these are the some districts which they have notified in relation to the Bihar, which are eligible for this deduction. If you set up the industry in these areas, in these districts of Bihar, you would be eligible for this 15% reduction under section 32AD. Now, what are the major difference between 32AC or 32AD? Or there are certain persons who are eligible for both kinds of deduction? I think the answer is yes, if they satisfy both the condition. In case of a company, if it sets up the industry, manufacturing industry in a notified backward area, and if it acquired a new plant and machinery for an amount exceeding 25 crores, then that corporate assessee would be eligible for both deductions. For 15% under section 32AD as well as 15% under section 32AC, right? There is another benefit given to these industries who sets up their undertakings in those areas, that is additional depreciation. At presently, the additional depreciation allowable only 20% to the manufacturing industries or the power sector undertaking. Now, in this case, if they set up their industries here in their notified backward areas of the specified states, then they would be eligible for an additional depreciation of 35%. The other condition that they have to restrict that additional depreciation to 50% if the new plant and machinery is acquired and put to use for less than 180 days. Now, the third proviso also inserted, which provides that you can carry forward and you can claim that balance 50% to the next succeeding financial year. So the 50% or 35%, if the plant and machinery is put to use for less than 180 days, then the 17.5% of the actual cost would be eligible in the next succeeding financial year. Here, the balance 50% of the would be allowable in the immediately succeeding financial year. Now, takes an example in here, X Limited set up a manufacturing industry unit in Vaishali district. This Vaishali district is notified backward area of Bihar, which is notified by the white notification notification board by CBDT. Vaishali district on 1/6/2015. This is on or after 1/4/2015. It invested 30 crore in new plant and machinery on 1/6. And further invested 25 crore in the new plant and machinery 1/11. Out of which 5 crore was second-hand plant and machinery. The second-hand plant and machinery are not eligible for any benefit either under section 32 AC, 32 AD or the additional depreciation. Only the new plant and machinery would be eligible for these benefits. So 30 crores or 20 crores out of 25 crore would be eligible for this deduction. This here it's acquired on 1/11/2015, so you have to make an assumption that the plant and machinery also put to use on these dates. Now we are making this assumption, and in this case, the new plant and machinery is put to use on 1/11, so it is less than 180 days. So it would be eligible for only normal depreciation or the addition of 50%. However, in case of these deductions, 32 AD and 32 AC, there is no restriction. You will be eligible for 15% in both the cases. Now, what you have to do, you have to compute the depreciation allowable under section 32. How will compute the depreciation? Here, the plant and machinery acquired on 1/6 is 30 crores. Here, the fee is 30 crores. 1/11 is 25 crore. 55 crore it is coming WTV. Now you have to compute the depreciation 15% on 30 crores and 75%, 50%, since it is put to use for less than 180 days. So it comes to 1.875. Here it's 4.5. So this normal depreciation. Now you move to the additional depreciation. Additional depreciation. Since this is set up in a backward area, it would be eligible for additional depreciation at the rate 35%, not 20%. Right. So 35% would be allowable on 30 crores. Whole of the amount is new plant and machinery. New plant and machinery, here it's 20 crores. The 5 crore been excluded since it is a second-hand plant and machinery. So 50% of 35%, this comes 17.5% allowable as an additional depreciation. So this is the depreciation part. You have to reduce the depreciation part from the WDV as on 31/3 to arrive at the WDV as on 1/4/2016. It comes to this. Now, what are the other benefits other than this depreciation? What are the other benefits available to this X Limited? It would be eligible for a benefit under section 32 AD as well as 32 AC. The answer is yes. Since it's a corporate assessee and the investment during the previous year exceeds 25 crores, right? So it would be eligible for 32 AC 1A. Section 32 AC 1A provides for this deduction, 50 crore. And it would also be eligible for a deduction under section 32 AD at the rate 15%. It comes 7.5 and 7.5. Now both the deduction would be allowable, and the total benefit is 15 crores. So here it will not be reduced from the WDV. It is of the actual cost. The deduction is allowable of the actual cost of the plant and machinery. Now, would your answer change where such manufacturing unit is set up by a firm, say X and company, instead of X Limited? Yeah, the answer is yes. Since the 32 AC 1A deduction is allowable only to a corporate assessee, they would not be eligible for this reduction of 15%. Only 32 AD benefit would be available. So it would be eligible for a deduction of 7.5 crore under section 32 AD. Now, what are the? This is all related to the PGPP. There are certain other amendments also for this. You should refer to the supplementary study paper 2015. Now we will cover some of the amendments which are brought in under the chapter 6A for deductions. Deduction under section 80C. Section 80C provides for a deduction in respect of investment in a specified instrument. If you invest in certain specific instrument, then you would be eligible for this deduction. The maximum limit of this deduction is 1,50,000. Here, What is the amendment? Here they are also allowable, the deduction is allowable in respect of the deposit in Sukanya Samriddhi account scheme for the welfare of girl child. For the they want, what they want to do, they want to provide a welfare for the girl child, so that they will invest for the future benefit of that girl child. They introduce this scheme, and in case they have what, you will be eligible for this deduction. This, what are the tax benefits? Certain tax benefits are allowable, that if you made investment in this scheme, you would be eligible for ATC deduction, plus the interest accruing on this deposit would also be exempt from income tax, and any benefit withdrawal from this scheme would also be exempt. So it's EEE, exempt, exempt, exempt scheme. Here, the scheme can be taken by the person in his name or in the name of girl child, or any girl child for whom such individual is a legal guardian. You can take this scheme for the benefit of a girl child. You can make an investment. You would be eligible for a deduction under section 80C. Section 80C. For the other amendment, section 80C, I told you that Sukanya Samriddhi account scheme being inserted. Then there is an amendment in section 80CCC. Section 80CCC, here the limit of deduction been increased from 1 lakh to 1,50,000 in order, with a view to increase the social security. Section 80CCC1 has been amended to raise the limit of deduction from 1 lakh to 1,50,000. This deduction is available to an individual, and for if they pay or deposited any to affect or keep in force a contract for annuity plan of an insurance company, life insurance company, then they would be eligible for 80CCC deduction. 80CCD1 also have certain amendments, that in case of contribution to NPS of government scheme, there is a restriction that that deduction cannot exceed 1 lakh rupees. Now that restriction has been removed from this section. So the deduction is allowable to 10% of salary or 10% of gross total income. In case of employee, if they are making a contribution towards the NPS scheme, there is a restriction that deduction cannot exceed 10% of the salary. In case that other assessees who are not making a contribution as an employee, then the deduction is restricted to 10% of GTI. The overall deduction under section 80C, 80CCC, 80CCD1 cannot exceed 1,50,000 by virtue of section 80CC. Now there are another section being inserted, section 80CC, subsection inserted under section 80CCD1B. So if you are making a contribution to the NPS notified by the central government, then you will be eligible for additional benefit of 50,000. This is outside the limit of 1,50,000 as provided under section 80CCE. This is additional benefit. So it's increasing the security for the sake of providing a more security, social security. This kind of deduction being provided. So this additional deduction is a benefit. How we proceed? If you are making an investment, suppose in 80C, 80CC, and 80CCD1, in this you already make a certain investment which exceeds the limit of 1,50,000. Then the other fund, what you can do? You can invest here in NPS, and you get an additional benefit of 50,000. I will explain this with an example. Here, Mr. A, employed with ABC, is an employee, and he made certain kinds of investment, deposited 1,20,000 in PPF, paid life insurance premium of 15,000 on the policy taken on 1/5/2012. See, there is a provision in here also, certain restriction that the premium amount cannot exceed 10% or 20%. You have to see the date. It's honored after 1/4/2012. So it's 10%. The premium amount allowable deduction in respect to the life insurance premium cannot exceed 10% of the sum assured. The sum assured is 1,20,000. So only 10% of it is allowable as deduction. It comes to 12,000. Right? 1,20,000 PPF, up to 1,50,000 you can invest. Here he is investing 1,20,000. So whole is eligible for deduction. Deposited further, he deposited 30,000 5-year term deposit with bank. It is also eligible for deduction under section 80C. All these three are eligible under section 80C. Now he contributed towards pension scheme, NPS of central government 1,80,000 being 15% of his salary. There is a restriction that this deduction under section 80CCC cannot exceed 10 CCD cannot exceed 10% of the salary. Here he is making contribution 15% of salary, right? He is making 1,80,000. Now you have to compute the deduction available to Mr. A under chapter 6A for AY 16-17. How you will do? You have first 80C deduction 1,20,000 plus 12,000 plus 30,000. It comes to 1,62,000. There is a limit under section 80C itself that it cannot exceed 1,50,000. So you have to restrict there itself 1,50,000. Now you move to the 80CCD. 80CCD mein how will compute? He is making a contribution of 15% of salary, right? 15% you have to compute 10%. But before availing this, before claiming this deduction, it is beneficial for Mr. A to claim additional benefit which is provided with the amendment under section 80CCD 1B. Here he can claim up to 50,000 additional benefit of his deduction. So he will claim 50,000 here, and the remaining portion that comes to 1,30,000 he can claim under section 80CCD 1, provided it should not exceed the 10% of salary. So 10% of salary comes to 1,20,000. It's 1,20,000. Only 1,20,000 is eligible. See, he already he already made certain investment which exceeds 1,50,000 rupees. So it's not beneficial for him to claim the whole deduction here. It ultimately comes to 1,50,000 only. Now whole of the 2,70,000 has to be restricted to 1,50,000. This is the benefit to Mr. A that now onwards he can claim additional benefit of 50,000 by investing in NPS. So 50,000 eligible. Only 50,000 plus that 50,000, 2 lakhs is come. Now 80CCD 2 also. Under section 80CCD 2, it provides for a employer contribution, reduction in respect of employer contribution. What you will do in case of employer contribution, also making a matching contribution was made by ABC Limited. This is an employee. He is also making a similar contribution, that is of 1,80,000. This what you will do, you will allow whole of the thing. First, in that case, what you will do, you have to include that amount first while computing the income under the head salary. Means 1,80,000 you will include while computing income under the salary, and it further has to be restituted 10% of salary. It comes to 1,20,000. It cannot exceed 10% of salary. So the deduction under section chapter 6 would be 3,20,000.
The employer's contribution, initially the full contribution will be included as part of salary. 1,80,000 you will include it as part of salary. But when it comes to providing deduction under 80CCD 2, that will be restricted to only 10% of salary, 1,20,000. Net effect is at 60,000 becomes taxable.
Now, would your answer be different in Mr. A contributed to be 1,20,000 being 10% of salary towards NPS of the central government? See here, as the whole of the limit being exhausted by investing in 80C itself. So it is beneficial to claim first 80CCD 1B. So 50,000 first he claimed here. So and the this is 10% of salary. That comes to 1,20,000. If you include here, the total comes to total cannot exceed 1,50,000. It will not make any difference if the contribution is 10% or 15%. The restriction is 10%. Whatever the amount you included, it has to be restricted to the overall limit of 1,50,000. So it will not make any difference in computer deduction under chapter 6A in that case also.
What will happen in that case? The total contribution is only 1,20,000. There again, for 50,000 you adjust against 80CCD 1B. This figure will become 70,000, 1,20,000, because totally it's 1,20,000. 50,000 you are claiming under 80CCD 1B and 70,000 under 80CCD 1. So the total figure under 80 total will be 2,20,000, which will anyway be restricted to 1,50,000 again. That is why your total deduction under chapter 6A will remain unchanged even if the contribution is 1,20,000 instead of 1,80,000.
This is amendment in section 80CCD 1B or the 80C. Now, what are other amendments in this chapter 80D? Under section 80D also they enhance the limit of deduction under section 80D, or further they allow a deduction in respect of medical expenditure in respect of a very senior citizen this year. Earlier, there is deduction is allowable. The limit is 15,000. That limit will increase to 25,000. And if the you are taking a health insurance policy and you are paying in respect of your a person who is a senior citizen, then that limit, that 20,000 limit will increase to 30,000. This reduction is available for both for individual if he is paying for self, spouse, or children, and dependent children. And if they are making a contribution, paying a insurance policy, medical insurance policy taken for their parents also, there is an additional deduction in respect of parents. Now, if the parents are senior citizen, the deduction is 30,000. If the parents are not senior citizen, then separate deduction of 25,000 is available in respect of medical insurance policy taken for the parents. Now, there is another move taken by the government that as a welfare measure towards a very senior citizen. What happens if the person is a very senior citizen? The life insurance companies hesitate to provide a medical insurance in respect of those persons. To provide a benefit to those individuals who is of the age of 80 years or more, plus they should be a resident in India. If a person is a non-resident, they will not be take this benefit. It is available in respect of resident in India, and if is of the age of 80 years or more, and who are unable to get the health insurance policy, then a deduction up to 30,000 would be available in respect of the medical expenditure incurred in respect of very senior citizen. Here there are three conditions: that the person should be 80 years or more and resident in India, and no insurance policy being taken in respect of that individual. See here, the deduction which is available already 30,000, that cannot go beyond that 30,000 limit. This is combined deduction of 25,000 or 30,000 if the person is a senior citizen. So the whole 50,000, it cannot go beyond the 50,000 limit, 55,000 limit. 30. If you are incurring medical expenditure for suppose to parents, for mother, if you are taking an insurance policy for mother, and for father who is of the age of 80 years or more, you are incurring medical expenditure of around 25,000 for father, and you are taking a policy for mother who is suppose she is also of the age of 80 years or more, you are taking a policy for her, it comes to 25,000. So the 25,000 are incurring expenditure of 30,000, it comes to 55,000. You have to restrict to that amount to 30,000 only. It cannot go beyond the 30,000 limit. Now, I will explain this provision with the help of this illustration. Here, Mr. Arjun, you have to compute a deduction to Mr. Arjun under section 80D from the following particulars. What he is doing, he is paying paid a premium for ensuring the health of self, spouse, dependent son. Mother also is paying. So there is a separate deduction for family, and for parents there is a separate deduction. So they is paying 10,000 here, 8,000 here, 4,000 here. It comes to 22,000. For mother, it's Mr. Arjun is paying 18,000. He is also paying preventive health checkup. The deduction is also allowable in respect to preventive health checkup. However, there is a separate limit in respect of that preventive health checkup. It cannot exceed 5,000 rupees in case of everybody, whole of the family or the parents. This limit is overall limit. It is not separate for family or separate for parents. It's an overall limit for both family as well as for parents, 5,000 limit. Plus, Mr. Arjun would be eligible for this benefit only if they make this payment other than cash. If they are making a payment by way of cash, they would not be eligible for deduction in respect of premium paid. However, they can make a payment in this preventive health checkup in cash also. Now, what amount he is paying? He is paying for himself 2,000, for his spouse 1,500. So it comes to 3,500. The 5,000 limit is not beyond the 25,000 deduction allowable. So it comes to 3,500, 25,500. This has to be restricted to 25,000 only in respect to family members. Now we will check how much deduction is allowable in respect to the parents. See here, he has also incurred medical expenditure of rupees 25,000 and 15,000 for his mother, aged 80 years. She is qualifying for, she is a very senior citizen, so she is of the age of 80 years. And father also is 85 years. Both mother and father resident. So they are very senior citizens. Now he is incurring medical expenditure. Plus, Mr. Arjun has taken a life insurance policy for mother. So mother would not be eligible for medical expenditure deduction, even if they are higher than the premium paid. They are higher than the premium paid of rupees 18,000. They can claim only in respect of premium. So 18,000 premium paid for mother, plus medical expenditure for 15,000 for father, and the preventive health checkup. What about the amount left under the preventive health checkup? Already we have exhausted 3,000 of preventive health checkup for family member. Now the remaining 2,000 he can claim. He is paying 5,000. Out of this 4,000, 2,000 he can claim for mother also. So it comes to 35,000, right? There is a limit of 30,000. This expenditure cannot exceed this limit. So 30,000 he will be eligible for parents and 25,000 for eligible for family members. Now we will check the solution. In respect of self, spouse, dependent son, it comes to 22,000. Now preventive health checkup, self or spouse, it pays 3,500. However, it cannot go beyond 25,000 limit, so it has to be restricted to 3,000 only. Aggregate comes to 25,000. He is paying a health insurance premium for his mother. He is also incurring expenditure. लेकिन वहाँ पे expenditure नहीं allowable होगा since he has taken the policy. So 18,000 for premium here, 2,000 the remaining balance, and the 15,000 is medical expenditure. So it comes to 35,000. The total allowable deduction in respect of parents is 30,000. It comes to total. The total deduction allowable under section 80D is 55,000. There are certain here आपको देखना है कि यहाँ पे बहुत सारी restrictions हैं 80D में. 25,000, 5,000 preventive health checkup के लिए. Preventive health checkup सभी के लिए है, not for family members separate है और parents के लिए separate है. But the limit of deduction in case of parents is separate. The limit of deduction in respect of if one of the person is senior citizen, parents are senior citizen, very senior citizen, there are certain bifurcation or certain kinds of restrictions provided under section 80D. So you have to clear your concept thoroughly by working out the more and more problems. Now we move to the other deduction. In respect of here in section 80D and 80U, it is under section 80D or 80U, deduction is allowable in respect of maintenance and medical treatment. If you are incurring an expenditure for maintenance and medical treatment of a dependent disabled, or the disability can be severe disability or otherwise. If you are incurring certain expense, there is a flat deduction of earlier it was 50,000. Now it is the limit being increased to 75,000 in case a person is suffering from disability. If that dependent is suffering from severe disability, the deduction which were for AY 15-16 is 1 lakh. Now it's increased the limit to 1,50,000. The dependent means a person who should not claim a deduction under section 80U, or the other person which is inter alia, the other person which are mentioned therein. So the dependent should not claim a deduction under 80U. It's a flat deduction. Whatever be the amount you are expending on such maintenance or medical treatment, you will be eligible for this reduction of 75,000 and 1,25,000 as the case may be. Similarly, under section 80C also, if a person with disability, the deduction would be 75,000, and for AY 16-7 earlier it was 50,000. And if a person with severe disability, that deduction would increase to 1,25,000 from 1 lakh.
So if the person with disability, they claim this deduction under 80U, then the person who is maintaining this disabled person cannot claim deduction under 80D. For example, suppose B is a person who's disabled and he has claimed 75,000 in his return of income. Then if A is incurring expenditure and maintenance of B, he can't claim deduction under 80DD since B has already claimed deduction under 80U. In case B does not claim deduction under 80U, then A can claim deduction under 80DD. And these deductions are actually irrespective of the amount incurred on the maintenance of the disabled. Even if you've incurred only 10,000, you can still claim 75,000.
Don't confuse with the other provisions, like certain other provisions होता है कि whatever be the amount expended or the amount to deduction, whichever is less is eligible. Now on 80 double day, it's a flat deduction. Now comes to section 80 DDB. Here the limit of deduction being enhanced limit of deduction been provided in respect of expenditure incurred for a very senior citizen. There is no other amendment in respect of other limit provided for senior citizen or the other person. Enhanced limit of deduction is provided for very senior citizen. In case of very senior citizen, a person who is a very senior citizen, a person being a resident in India, plus who is of the age of 80 years or more, the deduction of 80,000 would be available if you are incurring expenditure on medical treatment of certain diseases here. It is not a disabled person. Here the deduction is also allowable for the individual himself or the dependent person. Right? Other amendment here is that the assessee will be required to obtain a prescription for such medical treatment from a specialist doctor. Earlier, what the specialist doctor has to be should be working in a government hospital. That restriction is removed here. Now you can get the prescription of that medical treatment from a specialist doctor, irrespective of whether he is employed with a government hospital or not. And now what would be the limits now? In case of very senior citizen, if the limit is 80,000. In case of senior citizen being resident individual, the limit is 60,000. And other than this, the limit is 40,000. Right? This is the amendment this year, that enhanced limit for very citizen being provided in respect of a very senior citizen is 80,000.
In 80 DDB, it is not a flat deduction. It's the amount of expenditure incurred, or the maximum cap is 80,000, 60,000, 40,000. Whereas in 80 DD, it is a flat deduction.
So whichever is less is allowable here, the expenditure or this amount.
80G deals with deduction for donations to certain fund and charitable institutions. At present, Prime Minister's donation to Prime Minister's National Relief Fund, National Children's Fund is eligible for 100% deduction without any qualifying limit. Apart from that, there are 50 Prime Minister's Drought Relief Fund qualifies for 50% deduction without any qualifying limit. And for other charitable institutions and all, there's a qualifying limit subject to which you have deductions. Now, 3 new funds have been introduced, are now being made eligible for deduction at 80G, and these funds, donations to these funds will qualify for 100% deduction without any qualifying limit. These funds are the National Fund for Control of Drug Abuse, Swachh Bharat Kosh, and Clean Ganga Fund. So these 3 funds will qualify for 100% deduction without any qualifying limit. In case of National Fund for Control of Drug Abuse, it's a fund created by the Government of India in the year 1989 under the Narcotic Drugs and Psychotropic Substances Act. This is for control drug abuse. Swachh Bharat Kosh is set up by the central government to mobilize resources for improving sanitation facilities in rural and urban areas and school premises through Swachh Bharat Abhiyan. Contribution to this fund will also be eligible for 100% deduction, as all SSCs can contribute to such funds. Likewise, Clean Ganga Fund. Clean Ganga Fund is established by the central government to attract voluntary contributions to regenerate River Ganga. Whereas all SSCs can contribute towards Swachh Bharat Kosh, only resident SSCs can contribute towards Clean Ganga Fund. And here there is another condition. In the case of contribution to Swachh Bharat Fund, Kosh and Clean Ganga Fund, if suppose the SSC has already claimed that the same as a benefit under 135 of the Companies Act towards corporate social responsibility, the amount paid towards Swachh Bharat Kosh, if you have taken it as discharge of your corporate social responsibility under the Companies Act, then that amount will not qualify for deduction under Section 80G. Same with the case of Clean Ganga Fund. However, if you have not claimed it as CSR under 135 of the Companies Act, then you can claim it as deduction under 80G. However, please note that this restriction is not there in respect of Prime Minister's National Relief Fund, which qualifies as CSR under 135 plus as deduction under section 80G. 80JJAA. 80JJAA is a deduction in respect of employment of new workmen. Who's the eligible assessee? And any assessee deriving profits from the manufacture of goods in its factory. Earlier, only company assessees used to enjoy the benefit. This year, the Finance Act 2015 has made an amendment in this section whereby any assessee deriving profit from the manufacture of goods in its factory will be eligible for claiming deduction under section 18JJA. And what is the amount of deduction? It's 30% of additional wages paid to new regular workmen employed by the assessee in a factory in the previous year, and this benefit will be available for 3 assessment years, including the assessment year relevant to the previous year in which such employment is provided. So the deduction is 30% of additional wages paid to new regular workmen employed by the assessee in a factory. In case of a new factory in the first previous year, it should employ more than 50 regular workmen. The additional wages would mean the wages paid to new regular workmen in excess of 50 workmen. Suppose you employ 60 workmen, it's a new factory, you've employed 60 workmen, then wages of 10 workmen will qualify for deduction under 80JJA. In case of an existing factory, there is a condition that the increased number of regular workmen employed during the relevant previous year should be at least equal to 110% of the regular workmen employed in such factory as on the last date of the preceding year. If not, the additional wages would be nil. There should be at least a 10% increase in the number of workmen in case of an existing factory. Regular workman does not include a casual workman, a workman employed through contract labor, or any other workman employed for a period of less than 300 days during the previous year. If he's workman is on regular roles, he's employed in a factory, but he's employed only for 200 days in a year, means he will not qualify as a regular workman for the purpose of deduction under this section. Let's just understand the operation of section 80JJA with the help of a small example. Mr. A, an individual, he has set up a new factory which commences business on 1/4/2015. He has employed the following regular workmen. All are regular workmen at 5,000 per month. Now, all these 3 cases are independent cases. What will happen? Case 1, if A has employed 45 workers as on 1/4/2015, and that is the total number he is employed during the entire previous year. Will Mr. A be entitled for deduction? No. Why? Because the number is less than 50. Case number 2, he has employed 60 regular workmen. Then will he be eligible for deduction under 80JJA? Yes, he would be eligible, but in respect of 10 employees, amount in excess of 50. So 10 employees at 5,000 per month for 12 months. Because he's employed on 1/4/2015, so 12 months, which will give you 6 lakh. 30%, this is additional wages, and 30% of additional wages, 1,80,000, will be the deduction under 80JJA. Let us take the third case number 3, where he is employing regular workmen at different points of time during the year. On 1/4/2015, he is employing 10 regular workmen, 1/8/2015, 10 regular workmen, and 1/9/2020 regular workmen, and then 1/9/2015 another 20 workmen. Would he be eligible? No, because these two set 40 workers have been employed for less than 300 days in a year. So even if they are regular workmen, they don't fall within the definition of new regular workmen because they've employed for a period of less than 300 days. So here again the number does not exceed, only these 10 workmen would have qualified, but since the number does not exceed 50, no deduction under 80JJA will be available in case 3 also. Now let's take an example of an existing factory. On 31/3/2015, the number of regular workmen is 80. B Limited employs the following new workmen in the previous year 2015-16. We've taken B Limited in this case because the other assessees are eligible only from 1/4/2015. B Limited was earlier also must have been eligible for deduction under this section subject to fulfillment of other conditions. B Limited employs the following new workmen in previous year 2015-16. Casual workmen 50. However, casual workmen, no 80JJA benefit will be available because they are excluded from the definition of new regular workmen. Likewise, workmen employed through contract labor are also excluded from the definition of new regular workmen. Now, regular workmen. 30 workmen are employed on 1/4/2015, 25 on 1/5/2015, and another 25 on 1/8/2015. In these two cases, it is greater than 300 days. In this case, it's lesser than 300 days. So this will not qualify for deduction. 30 and 25 will qualify for deduction. Total number of regular workmen is 55. It exceeds 10% of 80. In the case of existing factory, you have to see the condition that it should be at least 110% of the existing number. So it should have been at least 88. He's employing 55 additional workmen. So it is additional wages paid to these workmen will qualify for deduction under 80JJ. So 30 workmen, 5,000 per month for 12 months, 25 workmen, 5,000 per month for 11 months. And that will give you additional wages, and 30% of that additional wages will be the deduction under 80JJ. 30% for 5,000 for 12 months comes to under 18 lakh, and 25 workmen for 5,000 for 11 months comes to 13,75,000, which is totally 31,75,000 into 30% will be 9,52,500. Now we will take up the income computation disclosure standards. Now under section 145(1), income chargeable under the head profits and gains of business or profession or income from other sources shall be computed in accordance with either cash or mercantile system of accounting regularly employed by the assessee. 145(2) empowers the central government to notify in the official gazette from time to time income computation and disclosure standards to be followed by any class of assessees or in respect of any class of income. So, by using the power, in exercise of the powers conferred under section 145, the central government has notified 10 income computation disclosure standards to be followed by all assessees following mercantile system of accounting for the purpose of computation of income chargeable to tax under the head profits and gains of business or profession or income from other sources. From assessment year 2016-17, this would be applicable. So these income computation standards are applicable for May 2016 examination, from May 2016 examination. It has also been clarified that all the notified ICDS, the 10 notified ICDS, is applicable for computation of income chargeable under the head profits and gains of business or profession or income from other sources, and they are not for the purpose of maintenance of books of accounts. This has been clarified. One more clarification is where there is a conflict between the provisions of the Income Tax Act and the notified ICDS, the provisions of the Act shall prevail to the extent. These are the 10 ICDSs which have been notified. Accounting policies, valuation of inventories, construction contracts, revenue recognition, tangible fixed assets, effect of exchanges in foreign exchange rates, government grants, securities, borrowing costs, and provisions contingent liabilities and contingent assets. Now let us see the significant deviations which impact the computation of taxable income on account of notification of the standards. Now, ICDS 1 is on accounting policies. Now, while ICDS 1 recognizes the fundamental accounting assumptions of going concern, consistency, and accrual, these accounting assumptions are recognized in ICDS also: going concern, consistency, and accrual. However, ICDS does not recognize the concepts of materiality and prudence in selection or application of accounting policies. Concept of prudence, what is it? Concept of prudence requires that provisions should be made for all known liabilities and losses, even though the amount cannot be determined with certainty and represents only a best estimate in the light of available information. Non-consideration of prudence in selection and application of accounting policies will have the impact of earlier recognition of income and gains and later recognition of expenses or losses for tax computation. We'll see now some examples of non-consideration of prudence in ICDS. In fact, as we go through the other standards, you'll be able to appreciate it in a better manner. So this I will take it up in the end, because when we go through the standards, you will be able to appreciate this non-consideration of prudence in ICDS in a better manner. ICDS 2 on valuation of inventory, what is the significant difference? Now, in case of dissolution of a partnership firm or AOP or BOI, the settled position as per the Supreme Court ruling was that If a firm is dissolved due to the death of a partner, the surviving partners reconstitute the firm and continue the business as before. The firm is entitled to adopt cost or market price, whichever is lower, for valuing inventories. This was settled by Supreme Court ruling in Shakti Trading case. However, now with the notification of ICDS, ICDS 2 specifically provides that for valuation of inventories in case of dissolution of partnership firm AOP or BOI at the net realizable value, notwithstanding whether the business is discontinued or not. So even if the business is going to be continued by the surviving partner, still my inventory has to be valued at net realizable value. This goes against settled principle in the Supreme Court ruling, but this is the principle laid down in the ICDS, that inventories have to be valued at net realizable value where there is a dissolution of a partnership. Construction contracts. Construction contract is AS7, used to be accounting AS7 versus ICDS 3. What are the differences? AS7 permits recognition of expected losses on construction contracts as well as contract cost, recovery of which is not probable, as an expense immediately. These are you are allowed to recognize it as an expense immediately. Expected losses on construction contracts and contract cost, recovery of which is not probable. Likewise, when total contract costs exceed total contract revenue, in such a case also, the expected loss can be recognized as an expense immediately as per AS7. However, there is an absence of specific requirement in ICDS 3 to recognize such expected losses on construction contracts immediately as an expense. So, by implication, what happens? You have to recognize these expected losses also on percentage of completion method. And this is a deviation from AS7. It may be noted that judicial rulings also so far permitted immediate recognition of expected losses as long as the same were in accordance with the accounting standard or justified by the principle of prudence or by the nature and circumstances of contract. However, with the notification of ICDS 3, now these losses have to be recognized on percentage of completion method and they can't be recognized immediately. Treatment of penalties arising from delays caused by contractors in completion of contract. AS7 allowed the decrease in contract revenue as a result of penalties arising from delays caused by the contractor. If there is a delay due to the contractor and penalty is payable, contractor revenue, such penalty can be decreased from the contract revenue as per AS7. However, ICDS 3 does not permit such reduction in contract revenue. Point in time of recognition of retention money. What is retention money? Retention money is that part of the contract revenue which is payable only on fulfillment of the terms of the contract. Only if you fulfill the terms of satisfactory completion of the contract work and after all the obligations under the contract are fulfilled, retention money becomes payable. So, AS7, ICDS 3 requires retention money to be treated as part of the contract revenue and recognized on percentage of completion method. As per para 10 of ICDS 3, contract revenue shall comprise the initial amount of revenue agreed upon in the contract and includes retention. So, contract revenue includes retention and contract revenue has to be recognized on POCM basis. By implication, retentions also have to be recognized on percentage of completion method. So this is against the judicial precedents. All these in CIT versus Associated Cables as well as Indian Fluid Boilers Limited, it was held that payment of retention money in case of a contract is dependent on satisfactory completion of work. Only when the work is satisfactorily completed, the right to retention money arises. Suppose some of you are not able to complete the work properly, or some of the obligations under the contract are not fulfilled, then retention money is not payable. And if I have already recognized it on POCM basis, then once again it becomes a problem. What happens ultimately when it is not recognized? Revenue recognition. Revenue recognition. AS9 deals with revenue recognition. And ICDS 4 for purpose of computation of taxable income, ICDS 4 revenue has to be recognized as per ICDS 4. Now, what is a major difference? AS9 requires recognition of revenue only if no significant uncertainty exists as regards the amount of consideration that will be derived from sale of goods, rendering of services, and use by others of enterprise resources yielding interest, royalty, or dividend. So in all the three cases, sale of goods, services, as well as use of enterprise resources, yielding interest, royalty, and dividend, revenue needs to be recognized only if there is no significant uncertainty regarding the amount of consideration. In case of ICDS 4, it requires revenue from sale of goods to be recognized when there's a reasonable certainty of ultimate collection. Fine, this is fine. But reasonable certainty of ultimate collection is not a criterion for recognition of revenue from rendering of services and use by others of persons' resources yielding interest, royalty, or dividends. By implication, revenue recognition cannot be postponed in case of uncertainty regarding collectability of consideration to be derived from rendering of services or used by others of persons' resources yielding interest, dividend, or royalty. Revenue has to be recognized even if this criterion is not fulfilled. In case of service transactions, AS9 permits revenue from service transactions to be recognized as the service is performed. You can either take proportionate completion method or completed service method, whichever relates revenue to work accomplished. AS9 gives you a choice. But however, ICDS 4 requires revenue from service transactions to be recognized only on the basis of percentage of completion method, which may, however, not be appropriate in case of all service transactions. Government grants. As far as government grants were concerned, Ponni Sugars Limited had laid down the rationale. If the object for which the subsidy is given is what will determine the nature of the incentive subsidy, whether it's capital in nature or revenue in nature, your purpose, the object of the subsidy will determine. If the object was to enable the assessee to run the business more profitably, then the receipt would be revenue in nature. On the other hand, if the assistance under the subsidy was to enable the assessee to set up a new unit or expand an existing unit, the receipt was on capital account. And this rationale of the Supreme Court rulings have been followed by several high courts in deciding whether the capital the subsidy was capital in nature or revenue in nature. However, ICDS 7 now has been introduced for dealing with government grants, except in case of a government grant relating to a depreciable fixed assets. With the exception of this, all government grants have to be reduced from the written down value or actual cost. In case of depreciable fixed asset, it has to be reduced from WDV or actual cost. All other grants have to be recognized as upfront income or income over the periods necessary to match them with the related cost. So the only exception is in the case of a government grant relating to a depreciable asset, that has to be reduced from the WDV or actual cost. All other government grants, irrespective of their object, will have to be treated as income either upfront, or if they have to match the related cost, then over the period necessary to match them with the related costs. But it has to be treated as income. Correspondingly, Section 224, Clause 18 has been inserted in the definition of income in 224 to include assistance in the form of subsidy, grant, or cash incentive, or duty drawback, or waiver, or concession, or reimbursement, by whatever name called by the central government or state government in the definition of income. Central government, state government, authority, body, or agency. It can be in cash or kind. Still, it will be included in the definition of income. The only exclusion is the subsidy or grant or reimbursement, which has been taken into account for determining the actual cost of the asset, as per explanation 10 to 43.1. In this case, it will be reduced from the actual cost for the purpose of computing depreciation. This is the only exception. Further, AS12 provides that government grants should not be recognized until there is a reasonable assurance that the enterprise will comply with the conditions attached to the grant and that the grant will be received. This condition is the same for ICDS 7 also. This is in line with AS12. That is, the enterprise has to comply with the conditions attached to them and the grant will be received. However, there is one point of difference. ICDS 7 goes on to provide that recognition of a government grant shall not be postponed beyond the date of actual receipt. Here, this condition is not there in AS12. So, even initial recognition of grants cannot be postponed beyond the date of actual receipt, even in a case where all the recognition conditions in accordance with AS12 have not been met. If you've received the grant, even if you've not met with all the conditions, still I have to recognize it because I cannot postpone recognition beyond the date of actual receipt, as per ICDS 7. ICDS 9 deals with borrowing costs. It requires all borrowing costs which are directly attributable to the acquisition, construction, or production of a qualifying asset to be capitalized as part of the asset. In this regard, all of you must be knowing the provisions of 3613 that allows you to claim interest in respect of capital borrowed for the purpose of business or profession as a deduction. The proviso to 3613 stated that the interest borrowed for acquisition of an asset should be capitalized up to the date the asset is first put to use, where such asset is used for expansion of an existing business. However, therefore, as per the proviso to 3613, only where the asset is used for expansion of an existing business or profession, capitalization was allowed. Whereas ICDS 9, there was no such restriction. Therefore, in order to align the provisions of ICDS 9 with the provisions of 3613, the condition that the purchase of asset has to be for the purpose of expansion of existing business has been removed while passing the Finance Bill 2015 in the Lok Sabha. So now the condition that the asset has to be purchased for expansion of existing business has been removed. Therefore, an interest borrowed for acquisition of an asset for the purpose of business will be capitalized up to the date the asset is first put to use, whether the asset was purchased for an extension of existing business or not. AS 16. As per AS 16, a qualifying asset is an asset that necessarily takes a substantial period of time to get ready for its intended use or sale. However, ICDS 9, as per ICDS 9, qualifying asset means land, building, plant and machinery being tangible assets, know-how, patents, copyrights, trademarks, etc. being intangible assets, inventories that require a period of 12 months or more to bring them to saleable condition. Therefore, only in respect of inventories, the time period of 12 months has been specified. Whereas in AS 16 clarifies that ordinarily a period of 12 months is considered as a substantial period of time unless a shorter or a longer period can be justified on the basis of the facts and circumstances of the case. AS 16 specifies a period of 12 months for all qualifying assets. ICDS, the 12-month period is specified only for the case of inventories. Therefore, in case of tangible assets like land, building, machinery and intangible assets, borrowing costs have to be capitalized even if the asset does not take a substantial period of time to get ready for its intended use. This is the difference between ICDS 9 and AS 16. Further, AS 16 permits, suppose there's a income or you earn income from temporary investment of borrowed funds, pending their expenditure on qualifying asset. It is going to take some time before I incur the expenditure on qualifying asset. In the meanwhile, I temporarily invest the borrowed funds to earn income. Then AS 16 permitted that me to deduct that income from my borrowing costs. However, ICDS 9 does not permit such reduction from borrowing costs. AS 16 also permits suspension of capitalization of borrowing costs during extended period in which active development is interrupted. If there are extended period during which active development is interrupted, the capitalization of the borrowing cost will stop during that period. However, ICDS 9 does not permit suspension of borrowing costs in such cases. Provisions, contingent liabilities and contingent assets. This is discussed under ICDS 10. AS 29 versus ICDS 10. AS 29 requires recognition of provision when it is probable that an outflow of resources embodying economic benefits will be required to settle the obligation. When it is probable. ICDS 9 requires recognition of a provision only when it is reasonably certain that outflow of resources embodying economic benefits will be required to settle an obligation. Therefore, as per AS 29, you tend to recognize a provision earlier. When there's a probability, you recognize it. Here, I have to wait till the time it's reasonably certain. Therefore, the recognition of a provision is postponed, which would result in higher taxable income at an earlier stage. Condition for recognition of contingent assets. Both AS 29 and ICDS 10 provide that contingent assets should not be recognized. Further, both AS 29 and ICDS 10 require contingent assets to be assessed continually. Thereafter, contingent assets and related income has to be recognized. In AS 29, if the inflow of economic benefits is virtually certain. In ICDS 10, if the inflow of economic benefits is reasonably certain. So this is a case of income recognition. Income recognition In ICDS 10, I do it at an earlier point of time. When it becomes reasonably certain itself, I recognize an income. Whereas, for accounting purposes as per AS 29, I will recognize it only when it is virtually certain. Income recognition is at an earlier point of time. Recognition of provision is at a later point of time for the purpose of ICDS. Therefore, the deviation between IAS 29 and ICDS 10 would have the effect of advanced recognition of income for tax purposes and consequently result in earlier payment of taxes. Now, in all the ICDS differences in ICDS and AS which we've discussed so far, one thing which we could clearly make out is that ICDS recognizes income at an earlier point of time, even before I recognize in the books of account. Just now we saw the example of reasonable certainty for recognition of contingent asset, whereas in books of accounts I recognize it at later point of time. Only when it becomes virtually certain I will recognize my income. Similarly, I gave you an example of recognition of retention money for construction contracts. As per ICDS, I have to recognize it as on percentage of completion method, whereas in case of AS7 does not require me to recognize retention money on POCM basis. So what happens? For tax purposes, I'm recognizing at an earlier point of time. Even in case of service contracts, recognition of income from services, I have to recognize it even if there is a reasonable certainty of ultimate collection is not there. Even then, I am forced to recognize my income. What happens? Later on, I'm not able to recover that income. Can I write it off as bad debts? What is the essential condition for claiming bad debts under 3617? That it should be written off as irrecoverable in the books of accounts. Amount of bad debts are there should be written off as irrecoverable. This is an essential condition. But now what we are doing, we are recognizing the income in advance for tax purposes. Such income has not yet been recognized in my books of accounts. Retention money, I am not recognizing it. Later, I am not fulfilling some terms of the contract, as a result of which retention money is not payable at all. But I have already recognized it. I have paid taxes on it. Now, what remedy do I have? I can't write it off in my books of accounts because I have not recognized it at the first instance in my books of accounts. I am recognizing it only for tax purposes because of ICDS. In such a case, in order to enable the assessee, in case some amount becomes irrecoverable, then where a debt or part thereof, a proviso has been inserted in 3617 to provide that the amount of such debt or part thereof has been taken into account in computing the income of assessee on the basis of ICDS without recording the same in the accounts. In the previous year in which such debt become irrecoverable or of an earlier previous year, recognition of income could have been taken place in an earlier previous year also. And such debt or part thereof shall be allowed in the previous year in which such debt or part thereof becomes irrecoverable. It shall be deemed that such debt or part thereof has been written off as irrecoverable in the accounts. Now, retention money. Let me just take the case of retention money. Contract revenue is 1 lakh. Out of that, 10,000 is my retention money. Percentage of completion method, 20% I recognize in first year, 30% in second year, and remaining 50% I recognize in the third year on POCM basis. So 10,000 may 2,000 I've recognized here, 3,000 I've recognized here. Now the contract gets complete in this year, but however certain obligations have not been fulfilled, as a result of which this retention money is not payable. But however, 2,000 and 3,000 I've already recognized in the earlier years and I've paid tax on it. Now what do I do? This year it will be deemed to have, I can't actually write it off in my books of accounts because books of accounts have not recognized this 10,000 at all, but for tax purposes I've recognized. So by virtue of this proviso to 3617, this amount of 5,000 is deemed to have been written off in my books of accounts, and therefore I can claim bad debts in this third year when it actually becomes irrecoverable. Now, something which I left out right in the beginning, the concept of prudence not being followed in ICDS. I wanted to take it up in the end because you now, after understanding all the ICDS, you will understand why prudence has not been followed in ICDS. Examples of non-consideration of prudence. Requirement in ICDS 7 on government grants that recognition of a government grant shall not be postponed beyond the date of actual receipt, even if conditions attached to the grant are not fulfilled. Because there's a restriction in ICDS 7 that I cannot recognize a government grant. I cannot postpone recognition beyond the date of actual receipt. However, as per the principle of prudence, only when the conditions have been fulfilled should I recognize a government grant. Here, this is an example in ICDS where concept of prudence has not been followed. Then, absence of requirement of reasonable certainty of ultimate collection for recognition of revenue from service transaction and use by others of person's resources yielding interest, royalty, and dividend. Why is reasonable certainty for ultimate collection is only a condition for recognition of income from sale of goods? Actually, that condition should have been there for recognition of revenue from service transaction and interest, royalty, and dividend also. Only then it would be in accordance with prudence. Since this condition is not there, prudence is missing in ICDS to this extent. Non-recognition of expected losses on construction contract and contract cost recovery of which is not probable as an expense immediately. There's no, whereas AS allows me to recognize expected losses immediately. ICDS I cannot do that. So ultimately I have to do it on POCM basis. Here again, it is not in concept of the prudence, which concept of prudence requires that I make proper provision for all as known losses and liabilities. In these three cases, I example that concept of prudence has not been followed in the ICDS. Now we come to assessment of various entities.
There is an amendment in relation to the investment funds. This year, financing 2015 has inserted Chapter 12 FB.
There are three queries which have come relating to ICDS. So I'll just answer those queries before we proceed to this. Monica has asked, ICDSs, are they applicable for May 16? Yes, they are very much applicable for May 16 because they are applicable with effect from assessment year 2016-17 in case of all SSEs following mercantile system of accounting to compute profits and gains of business and profession or income from other sources. They are all, therefore, it is definitely applicable from May 16 examination. Weightage of ICDS, there is no particular weightage of marks allocated for ICDS. It may be asked as a standalone question, or you might be required to apply ICDSs while solving a problem on computation of profits and gains of business on profession or a total income problem. In any manner, they can ask. I think Akhilesh, the other question also can be a standalone question, or it can be you might be required to apply it in a computational problem on business income or total income. Ma'am, can we answer certain case, Divyanshu Chokali, can we answer certain cases and select cases which can be answered on the basis of earlier decisions? Do we have to quote both judgments? In case of contrary judgments, you can quote either of the judgments. You can answer on the basis of rationale. Suppose the contrary rulings are of High Court, then you can answer on the basis of either of the rulings. But suppose the Supreme Court has laid down the law of land, like what I discussed in the case of use of land, whether it amounts to rent or whether tax is deductible at the 194C or 194I. Now it's been settled by the Supreme Court. So when the Supreme Court has settled the ruling, then you can't answer on the basis of High Court ruling. Otherwise, if there are two contrary High Court rulings, you can answer on the basis of either of the rulings, giving proper justification for your answer. Now let's go back to our amendments.
In relation to investment funds, a special taxation regime is introduced by way of Chapter 12 FB and insertion of sections under Section 10 and Section 115 UV. Earlier also, there were the provisions which provides for the taxability of investment funds in a way that known as VCC or VCF, venture capital companies or venture capital funds.
See, actually, now we are running short of time. So, in fact, this investment funds as well as REITs, they are covered in an earlier lecture. It's been dealt with at length in the earlier lecture, and that has been available in the cloud campus. So, it is a business taxation, developments in business taxation that covers REITs, that covers investment funds, investment allowance, as well as ICDS. Please go through that thoroughly, because we will go through some of the amendments which we have not covered in that lecture. Even rental REITs has been dealt with at length in that particular video in that particular mentoring session, which has been hosted on the cloud campus. Now, decrease in rate of royalty income and fee for technical services in case of non-residents. Last year, the rate of tax on royalty and fees of technical services was 25%. This has been reduced to 10% because smaller entities were facing a problem. Prior to that, it was originally 10%. It was raised to 25% by the Finance Act 2013. But because small entities were facing difficulties in paying such a high rate of tax, it's now once again reduced to 10% for assessment year 2016-17. Then in case of foreign companies, income accruing or arising to a foreign companies from capital gains arising on transactions in securities or interest, royalty or fee for technical services chargeable to tax at the rate specified in Chapter 12 are excluded from levy of MAT. So, the income arising to a foreign company from capital gains arising on transactions in securities or interest, royalty and fee for technical services chargeable to tax at the rate specified in Chapter 12. So, just now we saw that royalty and fee for technical services is now chargeable to tax at 10% and 115A. So, 115A falls within Chapter 12. Likewise, interest is also chargeable. Interest, there are different rates. Some interests are taxable at 20%, some are at a concessional rate of 5%. So, these income, when it's taxable at a rate of 5%, subjecting it to tax at, if it's a company which is in receipt of such income and they are liable to pay MAT at 18.5%, it will cause undue hardship to such companies. Therefore, this is a beneficial provisions which provide for exemption from MAT in respect of income accruing arising to a foreign company from capital gains arising on transactions in securities and interest, royalty and fee for technical services chargeable to tax at the rate specified in Chapter 12. Now, transfer pricing provisions have been extended to specified domestic transactions. This was done by the Finance Act 2012 with effect from assessment year 2013-14. And earlier it was in respect of only international transactions. It was extended to specified domestic transactions where in case of transactions between related parties under 40A, there are related party transactions, those related party transactions, or in case of an unit which is eligible to claim deduction, say under 80IA, and there's another unit which is not eligible to claim deduction under 80IA, and there's an inter-unit transfer of goods between these two units which don't correspond to the market value. In such cases, all these transactions together, the total transactions aggregate value exceeded 5 crores, then it was subject to the transfer pricing provisions. But now, since that was causing genuine difficulty to small SSEs, this limit has been increased from 5 crore to 20 crore. So, in the sum total of all the transactions with related parties under 4A, 80A transactions, 80IA transactions, inter-unit transfer between eligible goods and eligible unit and non-eligible units, all those transactions listed in 92BA, the aggregate value, if it exceeds 20 crore only, it will be treated as a specified domestic transaction and the provisions of transfer pricing would be applicable. If it's less than 20 crore, the aggregate price of specified transactions is less than 20 crores, then the transfer pricing provisions will not be attractive. Settlement Commission. What is a case before a settlement commission? Case means an proceeding for assessment of any person in respect of any assessment year or years which may be pending before an assessing officer on the date on which application for settlement is made. So an assessee can make an application to the settlement commission at any stage of a case relating to him. So in this context, case means a proceeding for assessment of any person in respect of any assessment year which may be pending before an assessing officer. So the explanation to section 245A gives the deemed date of commencement of settlement proceedings. It says up to 31/5/2015, the provision was such that a proceeding for assessment or reassessment or recomputation is deemed to have commenced on the date of issue of notice under section 148. Now what happens? Generally, the issue relating to escapement of income, it is in relation to more than one assessment year. So the assessee becomes eligible to approach the settlement commission only in respect of the assessment year for which notice under 148 is issued. He would become eligible to approach the settlement commission for other assessment years only when notice under 148 was issued in respect of those assessment years. This was creating a genuine hardship to those applicants. In order to remove this hardship, now this amendment is being proposed that where a notice under 148 is issued for any assessment year, a proceeding under 147 shall be deemed to have commenced on the date of issue of such notice, and the assessee can approach the settlement commission for other assessment years. Even if notice under 148 for such other assessment years has not been issued, but could have been issued under that date. It could have been issued, but it has not been issued. Even then, for one assessment year, if notice is issued, you can approach a settlement commission for other assessment years, provided you have furnished your return of income for that assessment years under section 139 or in response to notice under section 140. Now, there are 4 clauses in explanation to section 245A, giving the deemed date of commencement of settlement proceeding. The first clause, as we saw now, was relating to reassessment, where notice for reassessment is issued. Second clause is in relation to case where search is initiated under assessment proceedings under 153A are in process. Third case relating where you pass an assessment order in, to give effect to the decision of the appellate tribunal or a revisionary order under section 263. Fourth is the residuary clause, which we are now dealing with, in respect of which there is an amendment. This is a residuary proceeding for assessment for any assessment year, other than the proceedings for assessment or reassessments referred to in 1. 1 is reassessment, 3 and 3A are the other 2 cases. Search cases as well as an assessment order which has to be passed to give effect to the order of the appellate tribunal or the revision order. This is the proceeding other than these 3 proceedings. It would have been to as up to 31/5/2015. The position was that it would have been deemed to commence on the first day of the assessment year and concluded on the date on which the assessment is made. Now, this position has been amended with effect from 1/6/2015. It will now commence. Such a proceeding will commence on the date on which the return of income is furnished under 139 or in response to notice under 142. It was earlier, it would have commenced on the first day of the assessment year. Now the position, it will commence on the date on which the return of income is furnished. And concluded in a case where assessment is made, the date on which the assessment is made. In case where no assessment is made, on the expiry of 2 years from the end of the relevant assessment. 245D6B. It provided for rectification of a mistake apparent from the record by amending the order passed by the settlement. Settlement Commission will pass an order under 245D. Okay, and 6-month period was given to rectify any mistake apparent from record. Now, it is not necessary. Sometimes, the Settlement Commission will have to amend its order for rectifying a mistake apparent from record on an application made by the assessee or the principal commissioner or commissioner. Suppose the principal commissioner or commissioner or the assessee makes an application towards the end of the 6-month period, then it becomes difficult for the Settlement Commission to pass the order also within 6 months. Therefore, an amendment has been proposed in this section with effect from, amendment has been made in this section with effect from 1/6/2015. So, Settlement Commission may, with a view to rectifying any mistake apparent from the record, amend any order passed by it at any time within a period of 6 months from the end of the month. Earlier, it was 6 months from the date of the order. Now, it's 6 months from the end of the month in which the order is passed. When it's suo motu makes such an amendment, or where a principal commissioner or an applicant has made an application for rectification, then it's 6 months from the end of the month in which such an application is made. However, this application for rectification has to be made within 6 months from the end of the month in which the order is passed. the application, the principal commissioner or commissioner of the applicant wants to make an application for rectification, it has to do within 6 months from the end of the month in which the order is passed. And suppose it makes such an application, then the settlement commission has to pass an order within 6 months from the end of the month in which the application for rectification has been made with the principal commissioner or commissioner or applicant as the case may be. Now 245H provides for immunity from prosecution, where the applicant has cooperated fully with the settlement commission and made full and true disclosure of income and the manner in which the income has been derived. It will grant immunity from prosecution. Here, since the immunity is to be granted from prosecution, an additional requirement as an additional safeguard, it has been now provided that such an immunity can be granted only when reasons are recorded in writing. This is an additional condition which has been inserted for granting immunity from prosecution. In 245, abatement of proceedings in certain situations. What are the situations? One is when the application is rejected, then of course the proceedings will get abated. Then the application is held invalid, then also the proceedings will get abated. But what passes an order without providing for the terms of settlement? In such case, there was no date provided so far when it will get abated. So that is being provided now, stating where the settlement commission passes an order under 245D4 without providing the terms of the settlement, the proceedings before the settlement commission shall abate on the day on which such order under 245D4 was passed. Now, you know the opportunity, settlement commission and assessee can approach only once during his lifetime. That provision is there in section 245K. But he can always approach through another entity which he controls. There was no restriction relating to that. That restriction is now being made by the Finance Act 2015. Now it says that even a person related to the person who has approached the settlement commission once also cannot approach the settlement commission subsequently. Now who are these related persons? In case of an individual has approached, Mr. A has approached the settlement commission. Now, since he has approached the settlement commission, any company in which Mr. A holds more than 50% of shares or voting rights, any firm, AOP or BOI in which Mr. A is entitled to more than 50% of the profits, or a HUF in which Mr. A is a karta, these people also cannot approach the settlement commission. Likewise, when a company, say B Limited, has approached the settlement commission, any individual who has held more than 50% of shares or voting rights in B Limited at any time before the date on which the application, before the date of application before the settlement commission, such an individual can also cannot approach the settlement commission if B Limited has approached the settlement commission. Likewise, if a firm or AOP or BOI has approached the settlement commission, then an individual who is entitled to more than 50% of the profits in such firm, AOP or BOI at any time before the date of application before the settlement commission by such person cannot approach the settlement commission. HUF, if it has approached the settlement commission, the karta cannot approach. So these restrictions are also now provided. These related parties can also not approach the settlement commission. The assets seized under section 132 or requisitioned under 132A may be adjusted against the amount of existing liability under the Income Tax Act or Wealth Tax Act, or the liability determined on the amount of on the completion of assessment. So the assets seized under 132 search cases, 132A requisition cases were allowed to be adjusted only against the existing liability under the Income Tax Act and Wealth Tax Act, as well as the amount of liability determined on completion of assessment. Now, such assets can also be used to adjust the amount of liability arising on an application made before the Settlement Commission under 245C1. So now we've covered most of the amendments. In fact, because of lack of time, we are not able to complete all the amendments. All the amendments are discussed extensively in the supplementary study paper. And as I told you, as far as REITs, business investment funds are concerned, please go through the online mentoring which has been hosted on the cloud campus. Business taxation developments. Divyanshu Chokani. See, salary is also forming part of the syllabus of the entire income tax is covered at the final level. So you have to know salary. Even though generally this questions directly related to salary don't come at much at the final stage, but it is definitely within the scope of syllabus. There's nothing stopping paper setter from setting a question on salary. So you have to know, you cannot avoid salary or house property for that matter.
Divyanshu Chauhan again asked a question. Then also, do we have to do amendments in explanation 6 and 7 in section 9 as a result of Vodafone ruling? Yeah, of course you have to do.
All amendments made by the Finance Act 2015 are relevant for May 16 examinations. Do go through your supplementary study paper, revision test paper, the annexure to the RTP which contains the latest notification circulars as well as case law, plus 2 additional case laws which have been posted as addendum to the RTP in the BOS knowledge portal. Kindly go through all of them, and all the best for your examinations.
All the best, students.